Hello and welcome to Bulletin 135. Again, some interesting cases. The first was a statutory will case, RH, in which the court accepted that the will maker, who lacked capacity that they were asked to, in effect, make a will for, would have allowed the distribution of his estate 60% to the mother, 20% to the father, they were separated, and 20% to his siblings. However, the other argument was that testamentary trusts should be established for those involved, and two cases where statutory wills that incorporated testamentary trusts were ordered were quoted to the court. However, the court was of the view in this instance that the person would not have gone to that level of complexity in the will that they would have ordered, and accordingly was not prepared to overlay those basic distributions with testamentary trusts. The next will was a will involving a dispute over funeral arrangements. In this case, it was Frail and Shorey. They had a dispute between the parents, the father and the mother, and the usual principles were referred to, that at the common law the judge said parents have an equal say, you might say, with the funeral arrangements. However, here there was a dispute and the court needed to look further afield. There's the comment about what the courts normally look to, what the wishes might be of the children, in this case two young children, and what other family members thought, and as well as that the issues of what the cultural and traditional issues might be that would apply in a burial of this type. And they in the end determined that it would be in accordance with the mother's wishes. I just think it's worth mentioning here that we had a lot of cases up until, I suppose, the last decade or two, where we were always of the view that the executors or the administrators had the paramount right to determine those issues. I think now it's a much richer determination by the courts. They look far more broadly than saying, well, this is the administrator will determine the funeral arrangements. They look more broadly at those issues that I've mentioned. So it's interesting. I think it's consolidated that approach to burial disputes. The next issue was one involving an estate where a person alleged that they were a de facto and ultimately did not succeed in that assertion. And the court allowed indemnity costs to the executors in the matter, and there were principles about that, and as well as that, up to a certain point, the applicant was also allowed indemnity costs. But at a certain point, an offer which was rejected by the applicant was refused, which was a reasonable offer, obviously, as it turns out, and from that point on, the applicant, the alleged de facto, was required to pay the executor's costs on a standard basis. Just an interesting look at how costs play out, where there are disputes and where there's a winner or a loser, worth just having a look at. The final couple of cases, one of them was where a grant of letters of administration in an intestacy was made. The executor thought that the will was no good because it had been torn, and not by the deceased, and it was torn apparently in a break into the office where the will was held, and the advice was obviously incorrect, that the will was therefore invalid. However, about 7 years later, the executors realised that there'd been a mistake, the executor that is named in the will, and they applied for the revocation of the grant, the intestacy grant, and the probate of the will, which was ordered. Just an interesting case, mistake of law and fact, and it was therefore not a problem for the court to revoke the grant that had been made in error. Anyway, hope that those cases are of interest to you, and look forward to speaking to you next time.